So what does all this mean? As we go through this, you'll see that there are a lot of new things, and what's the impact on the bankruptcy case, and whether at the end of the day, do you want to recommend to your client to file under the Small Business Reorganization Act or not? So with that, I will let Mark start the program.
Okay, I think we should go to the first slide. This new act has a lot of inconsistencies, has a lot of ambiguities. Many people believe that with respect to unsecured creditors, this new law has completely gotten rid of the absolute priority rule. But with respect to secured creditors, lien holders, it completely retains the absolute priority rule. As a matter of fact, 1191B of this new law specifically incorporates 1129B2A, which is the part of the bankruptcy code that has the absolute priority rule for secured creditors. They did not incorporate 1129B2B, which is the absolute priority rule with respect to unsecured creditors. And what that means is you have a law that appears to say that if you just pay disposable income for 3 to 5 years and you satisfy the best interest of creditors test, creditors get at least what they would in a 7, you can confirm a plan. The law is not exactly that clear because those two tests I just mentioned, disposable income for 3 to 5 years and the best interest of creditors test, that's the confirmation standard in Chapter 13. And what's different about Section 1191 of the Bankruptcy Code is, in addition to that, it has the words fair and equitable. And it says fair and equitable includes best interest of creditors test, includes disposable income. But as we all know, the word includes does not mean that it governs everything that the words fair and equitable means. And the reason this is so significant is that the words fair and equitable are missing from Section 1325 of the Bankruptcy Code, but are in 1191B. So it has to mean something more than what it means in Chapter 13. So, I've talked to a number of different people, including judges, and most people right now believe that, it's okay if unsecured creditors get nothing if that's all the debtor can afford, if they're making their best efforts, et cetera, et cetera. And it may mean that, and it may not mean that. And we're going to go into what fair and equitable means later on, because there's some case law out there. I found one or two cases in particular where a judge, after BAP CPA passed in October 2005, some judges thought that the absolute priority rule was gone for individual debtors, and yet they realized that the words fair and equitable still had some meaning, and they started struggling with what that means. And so there's already some case law out there. It was incorrect case law, but there's already some case law out there where judges have struggled with this issue, and that I think is going to give us a good hint as to what lies ahead. But because many judges right now believe that this is like Chapter 13, and because that will be the rulings in front of many courts, the most important part, and the reason I can't emphasize enough, is that it makes a huge difference if you're a secured creditor or an unsecured creditor. I mean, huge difference, and that means that if you're a state court litigator and you're doing a settlement agreement, you want to make sure you're getting liens on assets. It's just critical. If you're a litigator, maybe you want to get rid of attachment and hope and pray that 90 days go by without the filing of a bankruptcy case so that you might have a lien on some assets. It's a huge, huge difference between secured and unsecured creditors like there's never been before. So I don't want to get too far ahead of myself, and I want to start going through the slides here. But
and looking at this slide, you can see the most important thing is that small businesses are like this. This is supposed to be a streamlined approach. So it's supposed to be kind of like a big Chapter 13. But let's go through with the advantages and the disadvantages. Why don't you start with the advantages?
All right. Only the debtor can file a plan, so you don't have to worry about competition from others. Disclosure statement's not required. The plan now does have to have a best interest of creditors analysis showing what creditors would have received in Chapter 7. It has to have a brief history of the debtor, but gone are the days where you have to file a motion to approve the adequacy of a disclosure statement and go back and forth and have to make revisions and spend $10,000, $20,000, $30,000 of attorney's fees on something that's really pretty simple. That's gone. And again, the whole point of this is to reduce costs and to make things go faster so that small businesses can actually afford it. Point number 3 is another critical one. Contested plans may be confirmed over an objecting impaired class. It's 1191B. That's a section I was talking about before that governs it's the cram down section, but it's important to understand that based on the language that's in 1191B, and this is the common understanding amongst judges, you can now confirm a plan even if you don't get a single class to vote yes. In fact, you can confirm a plan even if a single creditor does not vote to accept. You don't need the yes vote of anybody. That's a bombshell, and that's why these 11s are going to start looking like Chapter 13s, in the sense that they're going to, instead of having right now the success rate nationwide, at least in the legislative history for this bill, success rate's approximately 6% of all Chapter 11s result in confirmation.
Mm-hmm.
I mean, that number is going to go up from 60% probably to well over 50%, if not even substantially higher than that. So, we're looking
From
at
6% to 50%.
yes,
Yeah.
yes.
Mm-hmm.
I mean, we're looking at a very different practice, something that I think unless you've practiced Chapter 13, you don't really understand. If you do practice Chapter 13, these 11s they're more complicated because of executory contract issues. They're more complicated because of you're gonna have to do more lien stripping. It's gonna come up more often, but you don't need the vote of a single creditor to confirm a plan. That's a bombshell. What else? No absolute priority rule. I believe because the words fair and equitable are in there, it's possible that a less than absolute priority rule will still exist, in the sense that the absolute priority rule is pretty extreme. The equity or the owners can't keep anything unless unsecured creditors are provided for in full, 100%. And the way the statute's written and the way many people are interpreting it is, well, now debtors get to keep everything and unsecured creditors don't have to receive anything unless the debtor can afford that over the next 3 to 5 years. I think that's an extreme. I think we're going to end up with something somewhere in between, and judges are going to use the words fair and equitable to impose that. And each case is custom, each case is different, and you're going to have a lot of different outcomes. The other thing that's fascinating is in the Ninth Circuit, at least it's fascinating to me, Ninth Circuit, determination of whether a plan is fair and equitable is subject to reversal on appeal only for abuse of discretion, which means that very few of those cases will ever be reversed on appeal, which essentially means that whatever this judge's opinion is what the law will be, and you're going to get very different outcomes in different courts based on the particular judge and their particular beliefs about what this means, and you're going to be stuck with that ruling. So no creditors committee, again, it's designed to save money. There is going to be a Chapter 11 trustee in each one of these cases, but the Chapter 11 trustee in many ways is going to be like a Chapter 13 trustee. They're there to give their opinion to the judge. As a matter of fact, they're required to give their opinion to the judge about whether a plan should be confirmed, even about the value of collateral. So if there's a lien stripping motion under 506, the trustee is actually required to go to court and advise the judge what they think the collateral is worth and which appraiser's right. So really it gives these trustees an interesting role. The trustees are also, by the way, required to try to develop a consensual plan of reorganization. They're required to actually call the creditors and try to work something out, which is very unusual. No other trustee in any chapter has that duty, by the way, and it's an actual duty. But the point I'm trying to make is in many ways these trustees are going to essentially replace the creditors committee or fulfill the
And
role
we'll
of
go
the
through
creditors
in more detail later.
No U.S. trustee quarterly fees at all.
That's pretty important because it's not only $325 a month, but think about it, if you have a sale on their plan of $2 million, the quarterly fees are now 1% of that sale. So you're saving yourself $20,000. So that could be pretty significant.
Got it.
So now
the relaxed disinterestedness standard, that means that you can be owed $10,000, you up to $10,000, you as the pre-bankruptcy attorney, and yet you can still file the case. There's no conflict of interest, even though you're a creditor, up to that.
So that could be interesting. So you could be owed $10,000. You're retained by this debtor, and you could also be paid through the plan as a general and secured creditor and administrative expense, I guess.
Yep.
Interesting. Okay.
That is interesting.
See.
Then the last one, I'm sorry.
Well, go ahead.
Administrative expenses can be paid through the plan. That is true for the cram down plans. If it's a consensual plan, the administrative expenses have to be paid right away. If it's a non-consensual plan where they're using the cram down powers of 1191B, then administrative expenses can be paid over time.
Yeah, so that's an advantage for the debtor maybe, but not an advantage for the attorney.
That's correct. That is
so
correct.
Keep that in mind, right?